For our first speaker, I have the honor of introducing Joe Ortego. Walking the line between zealous advocacy and punishable misconduct can present challenges for in-house counsel and outside counsel. For instance, may you pay fact witnesses? What can you discuss with a witness during preparation? May you prevent a company witness from lying? Are you allowed to talk to a witness during a break in testimony? Can an in-house lawyer testify? Nixon Peabody, trial lawyer and former chair of the network, Joe Ortego gives us some examples of close ethical issues and what you may learn from the mistakes of others. Joe is also the president of the American Board of Trial Attorneys, or ABOTA, in New York. Please welcome Joe Ortego.
Good morning, everyone. Winning is good. We all want to be winners. This is not like the soccer camp in which everybody gets a trophy, the winners and the losers and the consolation prizes. We all want to be winners. And we want to be winners for a couple of different reasons. We want to zealously represent our client because at a lot of times we think they've been done an injustice. But there are other reasons. There are client pressures. The client pressures to win, whether you're in-house or outside counsel, are tremendous. The business pressures are very difficult on outside and in-house counsel lawyers. If you're an outside lawyer and you lose, it is not a good business development plan. If you're in-house counsel next to the CEO and your outside counsel and you on your team lose, it is not good for the personal development of your career at the company. And then there's ego. There's ego because we all have egos. We all want to be winners. And as we go on and become trial lawyers and litigators, we don't play sports anymore. Maybe we play golf, but that's not considered a very sophisticated sport for those of you who are going to play. So we have to win at the things we can, and that's what it comes. It comes into litigation. So we do what we think we can win at. And what's the problem with that? What's the cost sometimes of wanting to win? The temptations are out there. Well, the cost for doing the wrong thing is very simple. It's one, you could have an ethical violation and lose your license. That's very easy to do. The second thing is, it's your reputation, which you build upon. And think of your reputation like toothpaste. Once the toothpaste comes out of the tube, you're never getting your reputation back. So let's talk a little about that and walking what I call is the thin gray line, how to avoid the temptations of trying to win at any cost. And I just want to say this, when I was a prosecutor in New York, everything was black and white. You were wrong, you were right, everything was black and white. And as my hair turned gray, I realized that life was more than black and white. Life is very, very gray. So when we look at these situations today, we're going to talk about the gray situations that we have and what we're going to do. And how are we going to walk this fine, thin gray line to stay ethical, reputable, and zealously represent our clients. And let's do this by learning from the mistakes of others, because it's always fun to look at other people's mistakes and say, of course, we would never do these things. But I will tell you, a lot of people I know are tempted to do these things, and we all do these things. When the pressure gets great enough, it's just a matter of the amount of pressure before you crack and do something. Let's talk about the areas I'd like to talk about where people have gotten themselves in trouble. It's been payments of witnesses, preparation strategy, false testimony by witnesses, taking depositions. We seem to get ourselves in a lot of trouble there. Defending a deposition, and in-house witness special considerations for those who are in-house. Let's go to a hypo here. You talk about paying, can you pay witnesses? Of course not. No one is going to pay a witness. But let me give you a hypothetical that you'll see that you might be interested in. You have a big case, an employment discrimination case at your company, and you need the testimony of a former employee. And that former employee you didn't like. You canned that former employee, you kicked them out the door, didn't give them much, but now you need that former employee. All of a sudden you want that person. So you bring them into your office and you say, hey, I need your help. I'd like you to testify. And you get something that's probably like F you. And then you sit there and you say, well, I'm going to subpoena you. I'm going to bring you in. You'll see what you'll do. And then that witness will say to you, you know what? I'll talk about your crappy company, and I'll tell them everything they want to know. So what do? You say, how about giving them some money? Does that work? Well, there's been some unsuccessful strategies in this area, and one of the unsuccessful strategies was an attorney who went up to a company and said, I have some great information on something and I can testify for you in your case. And it'll be very good and very beneficial. And this attorney said, what I want is a $500,000 retainer and $10,000 a month, and I have information for you, and I'll be there for you, and I will testify for you. Well, sounds like a good business plan, does it not? Very, very lucrative business plan. Well, that lawyer is in federal prison. So that is paying a witness too much. But that's an easy one for us to all think about. It gets a little harder. What can you do? Can you pay travel expenses? Yes, you can pay travel expenses. Can you pay for preparation time? Yes, you can. But you can't pay that factory worker $2,000 a day to sit in your office for 2 hours. You've got to be reasonable, and it becomes gray on how much you can pay. And can you pay for the time it takes for that person to testify? Yes, you can. But you cannot pay for the result of that testimony. And that becomes kind of dicey, as we all know, with expert witnesses. But now, at least in the personal injury line, a lot of plaintiffs' firms use experts who have a separate company who finance their litigation. Is that ethical? Probably not, but you keep that in mind. So that's what we do on payment of witnesses. Let me give you another hypothetical. A very, very intelligent, this is the preparation of this, general counsel of a company, Ellis Mirsky, brilliant guy, doesn't have time for anybody, but he's brilliant and runs the company, but he's a very ethical guy. And he comes up to you and says, I know we're preparing for trial. I don't have time to waste with you, you young whippersnapper. Tell me what the jury instructions are. Give me the jury instructions. Tell me what I got to say to win, and we'll go forward. But I have no time for preparation. Is that improper? The answer to that is no, that is not improper. You may do that. You have to trust Ellis Mirsky to be honest, which we all know he is, and he will do a good job, but you can do that. You can do that, and you can give him the jury instructions. As a matter of fact, it's a pretty good idea to give your witness the jury instructions and explain the elements of proof. There is nothing wrong with that. Preparation is a key. What can you do during preparations? Now you have another situation of a witness. It all becomes very easy, you think. You have the heir apparent CEO of the company who's going to be your star witness. And you are very anxious about pleasing this person as an outside lawyer and an in-house counsel because this is going to become your boss and the source of your business. The CEO wants to make a very good impression on you and the company and tells you his or her story. And she goes on to tell you the story, and you sit there and you say to yourself, this is BS. I don't buy a word of this story. Something seems wrong. And he seems too much, or she seems too much of an advocate. What do? Are you required to put that witness on the stand? What should you do? Now, if you all think, oh, it's very easy, I would never proffer false testimony, you go back to your law firm or you go back to the CEO and say, I'm not putting this testimony on because the heir apparent, our biggest client, is a liar. Good luck. That's some of the realities of things and the economic pressures that happen. Well, the answer to that is it's very good. In most states, unless you're absolutely sure this person is lying, you're done. You can sit on your hands in a way and you can rationalize away. Only when it becomes absurd do you really have to jump in. And I've looked at the cases because who are you to judge the credibility of the witness? But what are you supposed to do about this? What could you do with that CEO? Well, I use the Ortego solution to it, which is not a legal solution. You're going to get caught. Don't be a fool. We're both going to get caught. This doesn't work. I think we can win this case by being very moderate and truthful. And that's the approach that you should take. You cannot knowingly offer false testimony. And what you can do also is refuse to put that witness on the stand. I could just imagine this right now. You're at trial. The CEO apparent wants to testify. And you go up to the judge and say, hey, by the way, I can't put this guy on, and I'm going to sit on my hands because he's a liar. Another successful business tactic. So you must rely upon yourself to convince that person to tell the truth. I think the safe harbor thing is a very good thing. It may work in a criminal case. It may work in a simple civil case where you're never going to see the person before. But good luck for your business development, and it's a tough decision to make. Do you, as an in-house lawyer, outside lawyer, want to live there by going to the court and telling the judge that you don't want to put the witness on? Good luck. It doesn't work. The client is lying. You've got a lot of different choices. You should exercise them. But I do think you're going to get caught. Every time I've seen a witness lie, they get caught. No one seems to pull it off because the maintenance of a lie, as I learned as a prosecutor, is more difficult than just telling the truth. And you can always do something with the truth. But when the lie falls apart, you're finished. And as the lawyer, what I've learned also in these cases is the person that lies seems to walk. I have seen very few people that have been indicted for perjury in these type of cases. But guess what happens to the lawyer and the lawyer's license? You're on the hook. And in-house counsel, I warn you, it's just a practical approach. The business people who make money never do anything bad. It's only the lawyers who spend the money. So you will be the designated scapegoat unless you do something about it. Protect your reputation. There are other companies too. Defending and taking a deposition. This is another area which I find interesting. You know, how much can you coach? How many private conferences can you have? What can you do about that? Well, you know, let's face it, we've all been there. You've got your witness there, you're taking the deposition, and the witness is starting to say some pretty silly things. And the witness is starting to lie. So you start with a lot of things saying, you know, you kick them under the table, but they know better. They keep on going on. Then your bladder becomes full, no matter what it happens. And you tell your witness, I think we need to go. And the problem is, if it's a different gender, you're not going to be meeting up in the bathroom secretly at the urinal or in the toilet. So now you've got a bigger problem. What do you do when that witness happens? Hey, you know what? What's been really the courts have done is that some courts say you cannot talk to that person. You cannot deal with that person. You cannot talk with them once cross-examination is started, and the jurisdictions differ. But once the cross-examination is started, a deposition, you should not be coaching that witness. And what's the penalty? So you go there and you talk to the person and you tell them anyway, you defy the rule. Well, you've just waived privilege because under these jurisdictions that do not allow the coaching, they say that the lawyer on the other side can ask that person everything you discussed about outside the presence for breaking that rule. You have waived the privilege. Good luck there, and check your malpractice policy because that's a lot of trouble. And how bad was that testimony that you really had to do it? Something that scares me in trial testimony and in deposition testimony is the bluffing, because I have done this, and I will confess I have done this. You have a witness on the stand, you're cross-examining the witness, and you're excited, and the witness is now getting butchered. In a rare event, nobody butchers witnesses if they're real trial lawyers. You're gaining points. You're feeling good. And finally, the witness says something crazy and outright lies. And you sit there and you say, ooh, what do I do now? How do I deal with this? I can't defeat the lie. So you sit there and you wonder what you should do. So you reach down and you pull out a transcript. You start playing with the transcript, and you say, you sure that's your answer? And you go to a particular page, witness panics, and the witness says, I made a mistake, and goes back to the answer that you love. Hey, wonderful, you bluffed them, because the pages are blank and there's no deposition testimony. Is that okay? Can you do that? What's wrong with that? You just caught a lousy liar. Why can't you do that? Well, the answer to that question is you probably can't do that. And the lawyer in Cincinnati had decided that he had done that at trial, and he pulled out a bunch of cassette tapes, put it on the table, and said, you sure you want that answer? Played around with the cassette tapes, had the little recorder ready to go, all excited. That lawyer was suspended for 6 months. Now, I don't necessarily agree with that, since I would be afraid of being suspended for 6 months, but you know, it's something you got to think about. You can't bluff in those circumstances. In-house counsel as a witness. The biggest thing I was trying a case in El Paso, Texas, in state court, a very fair jurisdiction, where I felt very even played in state court. I had a fair shot there, and I sat there, and the next thing I know, things were going pretty well for my client. So all I have to get is a subpoena for the in-house counsel witness that's sitting next to me to testify. Can you subpoena the in-house witness or the in-house lawyer to be there? It was the in-house lawyer, not the witness. What happens now? And what happens if I get, as the trial lawyer, get a subpoena to testify at trial? Well, that's a very effective tactic on behalf of the plaintiff's bar because now I'm disqualified. I'm a witness. Well, there's a whole statute on when you're not disqualified and when you're not as a trial lawyer. But here's a big issue, I think, for in-house counsel. In-house counsel, in some ways, we get tired. I guess you get tired of being in the legal department. What does the legal department do? They spend money. What do the business people do? They make money. So we as lawyers, even outside counsel, want to be part of the business decisions. And we get involved in the business decisions, and we get excited about the business decisions. And we sit at those meetings. Those meetings are not privileged. And I've seen, and then that witness or that in-house lawyer can be subpoenaed if it was not a privileged conversation. So you better be careful of what you do and what you don't do. In my circuit, we have elaborate rules of when an in-house witness can be called, in-house counsel can be called. It's difficult, but the disqualification and the waiver of privilege is an area where a lot of lawyers have gotten in trouble. And there are cases in which the client, the in-house lawyer, has been sued by their former client for waiving the privilege. So you'll see that there. And there's other interesting cases where general counsels have brought actions against their company for discrimination and where the courts have held that they have privilege. So it's kind of an interesting scenario if you're an in-house counsel, but be careful that you're not called to testify because I'll tell you this, if you're called to testify, you will do a lousy job whether you tell the truth or not because we're just not good witnesses. And if you think you're a good witness, you're crazy. First time I testified, I was great. I think I blew the case. Okay, other ethical issues that I wanted to bring up with is settlement negotiations. In my state, the state judge will take you in the back of the room and say to you, hey, how much authority do you have, Joe? And what's the insurance coverage on that? If you tell the truth, what do you think? Oh, we have $100,000 in coverage. Okay, Mr. Ortego, we can settle this case for $110,000. Thank you very much. Do you lie to the judge or lie to the mediator, or lie to your adversary about how much insurance coverage you have, how much you have of authority? Can you do that? The answer is no. The answer is once you open your mouth as a lawyer, you must tell the truth. You have no other choice but to tell the truth. You've got to do that, and you can't do that, and you open your mouth, and there's been private rights of action in a medical malpractice case where you said, we've done this, and this is all the coverage we have. It wasn't true. They brought a private right of action. There's been situations where lawyers have said, well, we settled a similar case for $50,000, and that's exactly what we did. It wasn't true. They were able to bring a private right of action because the lawyer lied. A couple of other miscellaneous things that I wanted to talk about was filing multiple pleadings. You file multiple pleadings in different courts. Can you go look judge shopping? You have a preliminary injunction. There's a different judge on call each day. Can you wait to find the right judge? The answer is yes. You can shop all you want. Can you wait to file a complaint to get the judge you want? Yes, you can. Can you file 13 complaints in different jurisdictions to get the judge you want? The answer is no. And finally, the thing I'd like to talk about, which is the most interesting thing for me recently, is what can you put in pleadings? You know, we have immunity, whatever we put in pleadings. And in a recent case, in a breakup of a very famous and very prestigious, or ex-prestigious plaintiff's law firm, one disgruntled wife of one of the partners decided to file a defamation suit against the other partner. 115 pages of complaint in a single defamation action, and 200 exhibits. And in those exhibits was each of the women that this guy had an affair with, the illegitimate children, the mistresses, pictures, and all of that. Does she have immunity? And by the way, she was a lawyer as well. Very good for the client's personal reputation at home on his wife. Didn't work out too well for him there, but do you have immunity? And now, theoretically, you do have immunity, but courts now are saying that if you abuse that immunity, you can be sanctioned and you can be subject to another action as well, which I think is interesting. Listen, it is a difficult thing to do. We have tremendous pressure on us as lawyers. We want to do the right thing. We are good people. We are the guardians of our profession. and our reputation. I do not like the lawyer jokes. I find them embarrassing. We are good people, but let's try to stay good people. And as Yogi Berra said, when you get to the fork of the road, take it. So I ask you to do that. Thank you very much.